one of the writings that I submitted. These were the early days in respect to interpreting the section dealing with the rights of, in respect to matrimonial property. I believe that I gave a solution that shows that I was thoughtful in respect to the impact of my decision to the parties that were before me. It required that I interpret the provision in the Constitution, and my lady, in respect to the resolution that I gave, I found that the contribution of a married woman, and therefore her share in matrimonial property, must be gauged from her contribution, never mind whether it is monetary. It could be in terms of non-monetary contribution. In the end, the approach I took, I think, has been vindicated by this court, by the Supreme Court. Thank you.
In the case of Ogen Toto?
Yes, yes.
Very well. I will now move on to give this opportunity to Justice Commissioner Sishale to take it from here.
Thank you, Honorable Chief Justice. Honorable Tuyot.
Yes.
Long before the promulgation of the 2010 Constitution, and whilst you practiced law in Eldoret, the position of the law was that it did not matter how evidence was obtained. The sole consideration for the admissibility of the evidence was whether the evidence was relevant. Am I correct in that summation?
Yes, I would think. Generally, yes.
Yes, generally. Now, the position has since changed, and the Supreme Court, which you seek to serve in, has departed from that position to the extent whereby the main consideration these days is how was this evidence obtained. By way of illustration and citing the cases that have been decided by the Supreme Court, can you take us through this journey?
Thank you. I think, my lady, you have tried to contrast the position prior to the new constitution and after. The consideration prior to the new constitution was the question of relevance of the evidence, the question as to whether it can help resolve the matter or the dispute before the court. The shift has been informed by the heightened application of the Bill of Rights and the fundamental freedoms. It has also been brought to the prominence of questions of good governance, and Article 10 have been brought to bear, so that whoever is obtaining the evidence must be wary of obtaining that evidence using illegal means or unlawful means. I had the opportunity, my lady, when we were considering the matter involving the DCJ in a 5-judge bench, to consider that question. And our position, the position we took, is what you have just stated, that where there is a breach of a fundamental right, which impacts negatively on the administration of justice, so that it's a bigger picture. It's not just about the individual whose privacy has been breached, but its implication on the general administration of justice. Then the courts would shut out that evidence. Of course, it is still controversial, because I know that in the UK, there is a tendency for the courts to fall back on the old position. I am not too sure that I can recall any of the Supreme Court decisions in that respect.
All right. The decision that you referred to, the matter of the DCJ, was a criminal matter.
Yes.
What about in the area of civil law? Any decision that come to mind?
In the area of civil law?
Yes.
Must it be from the Supreme Court, my lady?
Supreme Court, yes.
Okay.
We are confining ourselves to this
Okay.
Supreme
All right,
Court.
all right. No, I can't recall any.
All right. The Njonjo Mue case, does it ring a bell?
Yes, it does. It does.
What did the Supreme Court say in that matter?
The Supreme Court held that because there was a breach of privacy of the litigant, then the court needed to frown upon parties taking shortcuts in respect to obtaining evidence.
So that I've given you one case, another one?
I cannot recall.
What is famously known as the SGR case? SGR case, Kenya Railways Corporation versus Okio Mtata and others.
No, that doesn't come to mind.
It doesn't ring a
Yes,
bell.
yes.
So in your own view, this question of whether evidence is admissible being pegged on how it was obtained, do you think that that is a fair state of affairs?
One of the considerations that I would give as a judge confronted with that question is the nature of dispute and the impact of the evidence that has been shut out. If the dispute that is before me is one that involves as well the rights of other people in terms of fundamental breach, and the infringement can be redressed or remedied in another forum, then I think there would be a question of balancing. Has the evidence that has been shut out, what impact does it have on arriving at a fair decision in the matter that is before me as a judge?
All right, Judge, I hear you. But let's take